morning. Please be seated. We're here for oral argument on EH versus Honorable Slayton et al. It's our number CR 24-0245. A couple things before we get started. All counsel experience. Know you each have 20 minutes. You may keep whichever time you like for rebuttal, but you have to keep your time yourself. Also, Justice Mary Elena Cruz has recused in this matter, so we have returning from the benches from Tucson, former Justice John Palander. So we thank you, Justice Palander, for making the trip up, as always, and filling in for us today. So with that, please begin this class.
Good morning. Colleen Place. I'm a victims' rights attorney with Arizona Voice for Crime Victims, and my office represents the petitioner, EH. I do intend to reserve about 5 minutes for a rebuttal if possible. The future lost earnings of a murdered child are an economic loss under 13-105. Howard encompassed future lost earnings. Howard and Division 2's Hansen interpret 13-105 in a way that reads 13-105 in harmony with Arizona's restitution provisions.
This class, before we get too far down the line on lost earnings, future lost wages, one question I have as far as the status of EH in this matter. From what I read from your brief and I guess from the transcript below that it said that EH is acting as the lawful victim representative for JH. Is that correct?
Yes.
So I'm just wondering how that works. So these are not her own separate restitution, let's say damages, restitution losses. What she is here for are for standing essentially in the shoes of JH, which I guess would be the estate, but it's that representative. Is that accurate?
That is accurate, Your Honor. EH is acting as JH's lawful representative under 13-4403, and the court did find at the April 27th, 2023 status conference, it is in the transcript that Judge Slayton did find that EH is the appropriate lawful representative for JH.
Thank you.
I want to be clear, too. EH is JH's sister, correct?
Yes, Your Honor.
So why go with the lawful representative part of this instead of her just being the sister under the constitutional and statutory definitions?
Your Honor, that may be a possibility, but...
Well, it's clearly set forth, so why go with a lawful representative?
In this case, the losses that she's seeking are losses that are JH's future lost wages, and those losses under the Wilkinson test are direct to JH.
So as a sister, though, she qualifies as a victim under the constitutional and statutory definitions, correct?
Of course, Your Honor, yes.
Right. And JH would have a right to lost wages if we go with the argument that you're presenting, correct?
Correct, Your Honor.
And a sister then satisfies the definition of a victim and would stand in the shoes of JH, correct?
Correct, Your Honor.
Okay. So you're losing me why you have to go to the lawful representative point.
Initially, when the case was first charged, the county attorney's office had appointed a victim advocate as JH's lawful representative, and we sought, after EH was adopted and became an adult, that she would be the more appropriate representative. But I do see your point, Your Honor. EH is a victim in her own right and can make the request.
Well, let me be clear on that then, because that is an issue, at least for me, and that's why I wanted to get it straight. Because if you're looking in terms of direct damages or direct flow of a loss from the crime versus consequential damages, I thought if EH is standing in the shoes of JH, then you're really looking at, did the lost future wages result directly from the murder of JH? Right. If he hadn't been murdered, would he have gotten those wages? Versus did the murder lead directly to the loss for EH? The answer seems like no, because she wasn't entitled to those wages absent the murder. You would have to be the heir or a beneficiary of a trust to get that. You needed something in between. That's why I thought you had asked for them to be the direct victim representative.
Well, I do see Justice Montgomery's point. I think it is a clearer argument when she's making that request, standing in the shoes of JH, making that request on his behalf. And I recognize that whether she, if they are ordered to JH's estate, whether she would be the beneficiary might be a different question. I think there's authority in Title 14 that would allow her to be the beneficiary since the biological parents
Counsel,
essentially.
let me pause you there.
Of
'Cause
course.
You're confusing this issue. The definition of victim under the Constitution includes both particular persons who have a relationship with the deceased and a lawful representative.
Yes.
Okay? You don't have to go to Title 14. You don't have to go to beneficiaries. If you just stick with the language here, and as I saw the argument in the trial court and what occurred there, that's where the confusion started. The confusion started by trying to figure out the relationship between EH and JH and how EH could even make an argument for restitution instead of sticking with the plain language, which just this court first said Nat v. Martone.
Of course.
We apply the plain language of the Constitution and the implementing statutes. So you're confusing me when you want to go to other titles and you start making an assertion that EH could be a beneficiary of JH.
Of course.
So you're going to have to unwind that and help me understand why we'd even go there.
And, Your Honor, we may not have to go there, and EH is a victim. That was clear after EH versus Slayton in 2018 in the Court of Appeals, and the trial court did find that EH is an appropriate lawful representative. So EH does have standing to make this request on behalf of JH. The courts below, in determining, in looking at the Wilkinson test set forth by this court, the courts below agreed that the first two prongs of that test were easily met, but when it came to that third prong of whether the loss directly flows from the criminal conduct, the courts below conflated the question with Wilkinson, and Wilkinson is the claim legally eligible, and does it flow directly from the criminal conduct? And the only question there for EH is whether there is another intervening cause that caused the loss, and the answer is no. The Court of Appeals below and real parties assert that EH would have to prove other intervening causes, which may come into play later at the time that the amount of the losses are determined, but for the purposes of Wilkinson and whether the loss flows directly from the criminal conduct.
Counsel, can I ask you a question?
Of course.
The trial court here did not hold a restitution hearing per se, is that correct?
That is correct, Your Honor.
It looked at the two competing expert affidavits and decided as a matter of law, apparently, categorically, that given the age of this deceased victim and the lack of any work history, earnings, et cetera, restitution for future lost earnings was not appropriate, right?
Your Honor, correct.
Let me just go on and finish.
Oh,
so
sorry.
my question is, assuming that this court ends up remanding to the Superior Court for a full-blown restitution hearing, and regardless of what that entails and how much evidence is presented or whatnot, would it be a permissible result after a full-fledged hearing for the trial court to reach the same conclusion that it reached? That is, that given all the evidence and the different factors that come into play here, it simply is too attenuated, factually and temporally, to meet the causal nexus requirement that Arizona case law seems to require for restitution awards.
I think the trial court, if this is remanded for an evidentiary hearing, could certainly look at the evidence and look at the reports and make a determination, and it would be its duty to make that determination that EH has met her burden of proving the economic loss.
Right, but my question is, would it be permissible after a full hearing for the trial court to decide the award here should be zero because of the attenuated nature of the claim?
Your Honor, I think if the trial court decided that, no, I think EH might challenge that ruling because expert reports routinely have been used when expert reports use the industry standard and proper assumptions are made and statistics are looked at. the trial courts in other contexts, in civil contexts, for example, have relied on those types of report, and the nature of those reports don't change based on whether a damage is being sought in a civil context versus as criminal restitution.
If there were a hearing ordered on remand, for example, by this court, what more, from your perspective, what more or additional evidence would be presented?
Your Honor, my client has expressed a willingness to adopt the real party's expert report, and we put that on the record. I think their expert report is very thorough. I don't know what other evidence would be required. However, I do recognize that the real parties would have a due process right to request a hearing, and the judge may have questions for the expert. But I believe that the report that would be available would be sufficient for an order.
But counsel, I mean, the standard would be a preponderance of the evidence for the trial court to be able to identify an amount of restitution to order. And to ask the question maybe a different way, if the court took a look at the two expert reports and arguments from counsel and nevertheless reached the court's conclusion, or the court reached its own conclusion that whatever the assumptions were by the experts, both one retained by EH and the one retained by real parties in interest, didn't quite get there for preponderance of the evidence standard, setting aside the fact that you could possibly seek an appeal of that. Nonetheless, if the court determined that it didn't meet the preponderance of the evidence standard, the court conceivably could enter an order of there's no restitution that can be ordered.
And I think that's right. If the trial court, I don't think EH would agree with that, of course, but I think the trial court, as the finder of fact and the gatekeeper, would be able to make that determination of the appropriate award.
I think the follow-up point of that, too, for any concern that, you know, for this court to categorically say that lost wages, even of a child homicide victim, equates to lost earnings, that doesn't necessarily mean that there will always be an entry of restitution in every case where an argument that there are lost wages could be made. That's a fair conclusion, right?
Of course, Your Honor, yes.
Is the defendant entitled to any discovery before in advance of a restitution hearing? I mean, we talked about the due process rights. Just can you lay that out for me, how the trial court would ensure there is a protection of due process rights?
Of course. I think the real parties would be entitled to EH's expert report, which had previously been disclosed. And if we intended to call any additional experts, I believe they would be entitled to conduct interviews and anything else relevant to the restitution portion.
Thank you.
Of course.
You referred, just while you're checking your notes there,
Sure.
You referred earlier to a memo decision by the Court of Appeals called Hansen.
Yes.
And Hansen says this in paragraph 24, it's a quote, "Restitution awards based on speculative amounts are prohibited." Do you agree with that proposition?
Yes, Your Honor, I do, and I think it's State versus Aniqua is an Arizona case that stands for that same proposition. But there is authority to support the use of expert reports and to overcome that speculative argument. And the closest case which I cited is Sarawak. There's also another of other federal cases that obviously just persuasive to this court, but Cienfuegos from the Ninth Circuit, and a few other cases where those expert reports have been relied on and the courts have awarded future lost earnings based on the expert reports. And just because a loss might be slightly harder to ascertain when we're involved, considering a younger victim who hasn't worked yet, it doesn't preclude an order for future lost earnings. Arizona's statute requires full restitution and that all economic losses are considered. And I only have about 6 minutes left of time, so if it's okay with the court, I would reserve my final time for a rebuttal.
Okay.
Thank you.
Good morning, Your Honors. David Eichner for amicus AACJ. Mr. Williams for the real parties will come up after I go, and I'm going to take about half the time, so I'll try to sit down at the 10-minute mark. This case implicates serious constitutional issues and concerns, issues that this court has danced around in Wilkinson and Reed by noting that a red line exists, but it's never come close to the line, and the doctrine of constitutional avoidance requires the court to interpret the restitution statutes consistently with defendants' federal due process rights, as well as the right to a jury trial, not only under the Sixth Amendment, but also the Seventh Amendment, which has not yet been incorporated, but it will be at some point maybe. In any case, in this case in particular, where petitioner asked for $3.3 million for future lost wages, where I'll retire not having earned $3.3 million myself. It seems absurd, but I would submit that in any case, even if we had a 26-year-old new graduate of law school who starts in a very large firm and we know what their future wages are going to be with better precision, that it still is not appropriate.
Mr. Eichner, I definitely understand your constitutional avoidance argument, but I do think that we've addressed that in Wilkinson and in the incredibly eloquent opinion in Reed, where we said that so long as the restitution is bounded by the standards that are set forth, it is not punitive. In fact, punitive damages are not allowed under the statute. It sounds to me that you're not, we've already dealt with, in my opinion, the constitutional avoidance question. It sounds to me like you're challenging the constitutionality of the statute, which is not before us.
I'm only challenging it if the court were to grant a petitioner's claim. I think that would cross the red line. That if $3.3 million was granted.
And that is not before us either.
Right.
First of all, as Ms. Clay said, they have said that they would accept the other experts' proposal. But beyond that, all we're going to do here, if we rule in favor of EH, is to remand it for a restitution hearing. So isn't this argument premature?
To some extent, like in terms of the exact dollars, it would be premature. But it's still something that the court needs to keep in mind. Now, turning to whether you can order restitution for future lost wages, I would submit that the answer to that is no when it's a deceased victim, that it doesn't matter if they're 6 years old, 26 years old, 46 years old.
Do you disagree with the Howard case that future lost wages can constitute restitution?
So in Howard, it was not challenged. So it's if something's accepted by both parties, it doesn't carry the same force of law. Well, so I do think Howard could stand to be revisited. However,
that's why. Let me just interrupt you, because that's why I'm asking. It strikes me, at least, I'm not aware of any case from this court which says that future lost wages can constitute restitution. So in this case, that's why I'm asking. Do you agree with that?
I don't entirely agree with it. I see where Howard was coming from, because what if, like, for example, somebody commits a crime on day one and pleads guilty and gets sentenced on day two, and the person's still unable to go to work. But if they're still alive, Howard involved a victim who was still alive. Wilkinson, the victims are alive. They're claiming their own losses. And the conversation that Ms. Clace had earlier about victim versus lawful representative was very illuminating to me, because it shows that in order to get future lost wages, they have to be claiming it for JH and not for themselves.
Counsel,
so they
let
can't.
me pause you there,
Yes.
because that's an incorrect conclusion. EH as a constitutionally defined victim, whether it's in her own right as a sibling of JH or as the lawful representative as it's explicitly set forth, would have a right to restitution standing in the shoes of JH. It really doesn't matter in that regard. So to take that and then say, well, there has to be a claim on behalf of an estate. There's no estate here. There's a deceased child victim and there's a sibling. There's no estate involved at all. And if you think that there's a requirement for there to be an estate for the award of restitution, and I'm going to ask for the authority for that, because if I follow the constitutional definition and I go down to the constitutional right at 2.1A8, so it's not just a statute here, that statute implements a constitutional right, and I go over to then the definition of economic loss in statute, I get the lost earnings. I don't see anywhere in there where there has to be a claim on behalf of an estate.
So there's two parts. The lost earnings is a separate question, but the first part of that is it actually does matter how EH gets to victim status, whether it's as lawful representative or as in her own capacity as a sibling of a deceased victim. Because under restitution statutes, she can claim her own losses because she's a statutory victim. So for example, if she suffered emotional trauma and had to go for therapy, that's her own loss. She can claim that. There's no dispute about that. But when it becomes JH's future lost earnings, then she has to, that's not her losses anymore. That's his losses. She's claiming it as a personal representative.
And that's where I think the confusion entered into this case before the trial court, because that's an incorrect assessment of our case law and the definitions. I'd like to know the authority for creating that distinction. She certainly could make her own restitution claim as a victim, and because she is the victim in place of deceased, I know you want to make a point, I'll finish. Deceased JH, she gets to assert rights on his behalf too.
So you said our case law says this, but that's not what our case law is actually silent on this. That's why this case court took this, I assume, is because it's an issue of first impression. On the other hand, the California Supreme Court in Runyon has addressed this. It wasn't lost wages, but it was still lost income related to a deceased victim. And California has laws very similar to ours. They have victim rights laws very similar to ours, where a victim like EH can stand in as a lawful representative or claim their own. And they upheld their prior case law that said that the spouse of a deceased victim can claim lost income because it's her loss because of spousal support, because she was entitled to the income that her husband would earn. But here we're dealing with siblings then, and we get, and this is where attenuation comes into play. And this is the language of Williams, if that's how you pronounce it, and other cases of Arizona courts where consequential damages are really about attenuation. And I tapped into Fourth Amendment law with attenuation because time is one of the things we consider. Also intervening circumstances, which this case has in abundance. But if we have to draw the line anywhere, Runyon really does explain well why we don't look beyond. It's the decedent's claim that is being then invoked by somebody else, and they're not actually losing the money if they're not working and they're not losing wages because they're deceased. And it may feel like the wrong answer because it feels like we're encouraging homicides instead of serious physical injury. But Runyon explains why that's not an absurd result, and people aren't going to be encouraged to kill their victims.
Now, if you would have the same attenuation speculation problems if JH had been horrifically disabled rather than murdered, but he would still be entitled to lost wages, would he not?
Well, it would be his claim at that point.
Right.
And so he would be speaking for himself. He would, assuming that, then it would be an evidentiary issue.
Right.
My argument here is because it's not JH making the claim.
So where is your authority, either in statute or in case law from Arizona, that EH does not stand in JH's shoes for purposes of a restitution award?
If you look at 13-4403, petitioner has cited it to support their position, but they've misquoted it. It doesn't say what they think it says. It doesn't say anything about how they get to claim somebody else's restitution for income that they haven't lost. There's nothing in 4403 that actually supports petitioner's claim. On the other hand, it seems to cut against it. I do want to talk about Sarawop as well, because Sarawop is not a well-reasoned opinion, and it actually cuts against what petitioner was arguing earlier, because the 10th Circuit said pretty clearly, If the trial judge decides to give zero restitution, that's allowed. But if we give trial judges abundant discretion and we don't have any limits on it at all, then it's basically a free-for-all in the superior courts.
We rejected that point, though, in State v. Patel, that it is not a free-for-all, that there are limits to it. And I heard from opposing counsel earlier that, yeah, a court would have the authority, if you couldn't meet the preponderance of the evidence standard, to enter an award of zero.
But I'm talking about the legal standard. The legal standard.
Well, the preponderance of the evidence being a legal burden of proof,
Yeah.
or a legal standard of proof, that's the legal standard here. You have to meet that, and if you can't do it and you enter an award of zero, then that could be legally permissible. And
If it's, I don't agree that saying that judges can do whatever they want without regard for like this is allowed or this is not
Counsel,
allowed.
I didn't hear anybody say that.
I think that if we don't like put a line and say that this is that the petitioners can't claim other people's lost income, that's not their own losses.
Well, but counsel, let me, for
And
just a
Justice
moment, I want to go back to this because I think it's important for everyone to understand how these rights work. The definition of a victim under the Constitution, victim means a person against whom the criminal offense has been committed. Okay? And if an offense has been committed against you, then you have a right to restitution for economic loss. If the person is killed or incapacitated, the person's spouse, parent, child, or other lawful representative, and then the statutory definition expands that to sibling, except if the person is in custody for an offense or is accused. So victim means a person against whom the offense has been committed, or if they're killed or incapacitated, others, which includes sibling. So a sibling then is a person against whom the offense was committed, who has a right to restitution.
They have a right to their own restitution.
Where do you find home?
That's exactly what the statute says. It does not say you get to claim somebody else's restitution. It says you get to claim your own restitution. I am running out of time, but another authority is Justice Hurwitz's concurrence in the Downey case, paragraph 35, which talks about how economic loss can't be something that would create a windfall. There has to be loss. And here, EH has suffered no loss in terms of, because they're not entitled to JH's lost earnings that they haven't received. I'm going to yield to Mr. Williams now.
Good morning, Your Honors. My name is Craig Williams, and I represent Linda Hester, but I'm here to argue on behalf of all the real parties in interest. I want to start by saying that the petition for review would allow theoretical awards of restitution based on conjecture and speculation and not on actual loss. What do I mean by actual loss? In Wilkinson, they said that the award can be without the intervention of causal factors. And what do we have here? We have a 6-year-old boy that died, and the state's, or excuse me, PFR says their expert begins his lost income at 21. So what happens between 6 and 21? The Court of Appeals kind of captured this, and I want to repeat it. Would he have been married? Because if he's married, there's a different error. If he'd have had a kid, there'd have been a different error. What education would he have had?
But why are they causal factors? I see the causal factor here as being the murder, which reduced his future lost earnings to zero. But why isn't the default assumption that this young man would have lived a normal life? All of these things that the Court of Appeals came up with, this parade of hypotheticals, those are intervening factors that might change the outcome, might change the amount. He might have gotten struck by a car, but they're not causal factors of him. They are subsequent intervening factors. They're not causal factors.
Well, just like if you're considering Howard. Howard happened, 12 years before Wilkinson? And Wilkinson set out the standard. So all those cases before Wilkinson didn't have that third prong. And the third prong talks about intervening causes. And I think the court here has to consider that because there is no actual loss. So if there's no actual loss, then there's nothing to claim.
I read that third factor as saying it has to be the direct cause, and I don't know what could be a more direct cause than someone having zero net future earnings than murder.
Well, the term speculate, theoretical, guessing, all those things that are happening, and that's what, you know, when you get into consequential damages, and all the discussions about consequential damages all lead back to the fact that you can't guess, right? You can't guess, and that's what's happened.
But the statute actually says lost wages. It's like you get A, but you don't get B, consequential damages. Presumably, if you have A, that's not B. So the default assumption under the statute is you're entitled to them.
I appreciate your point. And if it had been JH's actual loss and JH is what's coming for it, if they could prove any actual loss they did it, putting aside one of the quotes in one of the briefs was that somehow the defendants benefit from killing somebody and then come in and talk about speculative causes. I want to get back to the fact that you can't guess at this, and the statute, which is...
But counsel, your expert came up with some hard numbers.
With respect, can I answer his question first and then come
Sure,
back to you?
sure. Well, that'll keep me from getting in trouble later.
Yeah, no need to insult the justices as you're making an argument. Okay, 13-105-16. Economic loss does not include consequential damages, but they don't talk about future lost wages. They talk about lost earnings, and I would interpret that as lost earnings of JH, of which there was none, and EH is stepping in to get what doesn't exist. Did I explain that okay?
So you disagree with the Howard case from the Court of Appeals?
Yes. All those cases, every one of them talks about a reasonable relationship, right? You have to have a reasonable relationship with the loss.
But why wouldn't it be, I mean, one, it strikes me as more than ironic that if this child, JH, has simply been, as Justice Bullock said, just horribly injured but survived, but it impacted his future ability to earn a living, he could get that as future lost wages, at least according to Mr. Eichner. So but yet if he kills him, there's nothing. That seems ironic. And so I guess if you can respond to why that's not so. And number two, if it was a 17-year-old who had been killed, and maybe you know a little bit more about them, well, maybe it's less speculative, and you're able to come up with something with a reasonable relationship as far as what those future lost wages would have been. But why not at least allow it to go back to a restitution hearing for you all to make these arguments and to decide if it's too attenuated or too speculative to be able to be shown?
I understand what you're saying. I want to point out, though, in my opinion, we had a restitution hearing. We had, Judge Slayton said to all of us, you're going to have simultaneous briefings on the issue of restitution, and then I'm going to set a hearing. And so then we did go to the hearing, and we did make oral arguments, and in my mind, that's a restitution hearing. It wasn't an evidentiary hearing, but it was a restitution hearing. And following that is when Judge Slayton said, no, there's no loss here. And so I disagree that we didn't have a restitution hearing, so I don't see any reason to remand it because there is no actual loss. And so if I'm going to argue that a 6-year-old boy is not entitled to lost wages, it's the reason I'm saying that is there is none. And the only way you can... I'm sorry.
Let me ask a question there and maybe put a finer point on it. Because I'm listening to the arguments, and what I hear is instead of necessarily saying that lost wages can never be awarded as restitution for a child homicide victim, what I hear from the argument from the briefing is more that in this particular case, there isn't a basis upon which to order restitution, because of the speculative nature of the argument that you're making. I see that as two different things. Where am I wrong on that?
As I said in my brief, this is a solution in search of a problem, right? There is no conflict between this case and the Division 2 case, because Division 1 said that's not to say that future lost earnings are never available. The second part of that sentence is, it's just not in this case because there's no actual loss.
But I guess the problem and concern that I have is the trial court finding that lost earnings for a child victim, I'm reading from the transcript at page 164. Lost earnings for a child victim, I find, falls under consequential damages. I think that's where it's confusing the state of the law. Lost wages are not consequential damages. Nonetheless, lost wages might be too speculative to be awarded. And it seems to me that the Court of Appeals picked up on that, and they furthered the confusion by talking about a causal nexus within consequential damages. And that's why the questions I'm asking are more along the lines of, okay, it's not categorically consequential damages that it completely eliminates them from consideration of lost earnings. Rather, as I understand the arguments here, it's in this case, they're too speculative to be awarded, which I see as two different things. And again, am I wrong in coming to that conclusion?
And just to say, you're well over time.
Oh, I'm
So
sorry.
Please answer the question, but keep it as succinct as possible.
Okay, I appreciate that very much. I think where you have a case, this case in particular, but if you had any case where the report on lost wages was based on pure conjecture and speculation, which it is in this case, then no, you're not going to have future lost wages because there's no actual loss. Am I good?
You're good.
All right,
Thank you,
thank you.
Mr. Williams. Ms. Foss?
Thank you. The issue of EH's standing is not before this court. Both the trial court and the Court of Appeals seemingly affirmed that she can make this request. The issue of a jury trial is not an issue that was preserved in the trial court. It's a new issue raised for the first time by amicus AACJ. And, Your Honor, you are correct that Wilkinson did address the concern about the jury trial. Wilson had stated that our restitution statutes encompass only loss that directly flows from the criminal conduct, and it prevents our restitution schemes from conflicting with the right to a jury trial. As far as the People versus Runyon case in California, that case is distinguishable for a number of reasons. Runyon considered whether the personal representative could receive the diminished value of estate assets, including a coin collection, fencing equipment, the contents of the deceased victim's home. California analyzed Runyon under an analogous provision of civil law, which limits tort recovery to a decedent's pre-death damages. Arizona doesn't have a similar provision, and even if it did, I don't think, for purposes of victims' rights, I don't think you would be required to analyze our victims' rights statutes and the right to restitution under civil provisions. The court in Runyon noted in the very last paragraph of Runyon that that Marcy's Law, the right to restitution, does not require loss for a decedent's post-death damages, but that the California legislature could change that if they wanted to. And if you look at footnote 8 of Runyon, there's a little bbit more analysis on why it mentions Sarawak and why Sarawak was analyzed differently, that Sarawak, that the 10th Circuit wasn't required to analyze Sarawak under an analogous civil provision. As far as the conflation of consequential and speculative, the only question, that third prong of Wilkinson, the only question is whether there was another intervening cause of JH's death, and the answer is no.
I note that two of the defendants, they pled out to child endangerment, so that's the conviction for
Correct.
them. So for them, would the murder be an intervening event that wouldn't satisfy that third prong of Wilkinson?
No, Your Honor, and that was addressed by the Court of Appeals in 2021. Actually, after EH versus Slayton 2, this court had remanded with instruction for Judge Slayton to allow the real parties to withdraw from their plea agreements if they chose to do so. They did not. When we were in front of the Court of Appeals, when we were in front of the Court of Appeals, again, that issue came up, and I believe it's the last or second to last paragraph of that Court of Appeals opinion.
While you're drinking, so the question I would ask, though, is if we were to remand for a restitution hearing, that wouldn't foreclose the other real parties in interest from being able to argue that point.
I mean, looking at the 2021 Court of Appeals opinion, I think the court had found that the parties were already on notice at that time. They agreed to pay restitution in the plea agreement.
Right. And I mean, to that point, they agreed to pay restitution, but as we've been discussing here this morning, the amount of restitution would still be in question.
Of
And if
course.
there was an issue with the relationship between a crime that a defendant pled guilty to and any request for restitution, that relationship would still have to be satisfied in order for a court to order the restitution, correct?
Correct.
Yeah. So it struck me that's what I wondered too. Nobody really brought it up here, so I thought that if it goes back, that's something to be argued below, whether it would, in that situation, for those two defendants, that would be consequential because that direct flow arguably was interrupted or didn't directly lead to lost wages.
I could see that the real parties might make that argument, and I believe we touched on it at the status conference. My position is that it had been resolved in 2021 by the Court of Appeals, but perhaps that argument will be made. I am very low on time, so I would just respectfully urge this court to find that JH's future lost wages are an economic loss under 13105. Doing so would construe that statute in harmony with our other restitution provisions that require full restitution and a consideration of all losses. The Court of Appeals below conflated that third prong of Wilkinson, and the test set forth by this court in Wilkinson is the appropriate test to make that determination. I'd like to thank the court for considering this issue. It's an honor to appear before this court on behalf of a crime victim, and I would ask that you grant the relief requested and remand back to the trial court. Thank you.
Thank you. I thank all counsel for their briefing and their argument today. We will take the matter under advisement and issue a decision in due course. We will recess just to allow the next case to come forward and make some changes on the bench.